Someone going to kill you. Okay.
Yeah.
Mr. President, Your Honours, my name is Swati Bhatt, and together with my co-counsel, Mr. Chester Tan, we represent the prosecution. My learned opposing counsel, Ms. Charlene Reed and Mr. Derek Lee, represent the defense. I will be discussing on the issue of jurisdiction over the present case. My colleague will discuss whether there are substantial grounds to justify whether the charges brought against the defendant, Ms. Minsa, ought to be confirmed. With Your Honour's permission, my co-counsel and I would each like to speak for 15 minutes and reserve 1 minute each for rebuttal. The prosecutor's investigations in Arcania revealed gas vans were being used to eliminate a religious community, namely the Kapo people. Continued investigations after Arcania's withdrawal revealed human experiments were being conducted on the disabled. Ms. Minsa is inextricably associated with both events. She ensured that the gas vans operated optimally as killing machines against a religious community. She was also in charge of the human experiments conducted on the disabled and the helpless. Today, however,
She's in charge? Is she in charge?
she was in a senior position, Your Honour, and she had knowledge of the crime.
Can you point me to the paragraph that says that she's holding a senior position in the text?
On page number 2, paragraph 1, with the sentence that begins with, in January 2012, after a dispute, it's mentioned that Ms. Minsa worked as a medical assistant on research, focusing on degenerative brain disorder.
Sorry, paragraph 1, which line?
Line number 4.
It's looking at the wrong page.
Paragraph
Oh.
Paragraph 7.
Um,
7. Paragraph 7.
the second page, Your Honour, with the words.
Yes. Okay, I can see that. Medical assistant.
Yes, Your Honour. It's the prosecution's submission that this is an important post in any research organization.
Well, it's quite far from what you have said, like, from in charge to a senior position and then now to an assistant.
Your Honour, it must also be seen in light of the previous position. If you refer to paragraph 1
Yes.
of page 1, which says Ms. Minsa was born 1970, in that it's mentioned that she was a senior staff specialized in genomics and brain disorder.
Yeah, but that's a post somewhere else, isn't it?
Yes, Your Honour. But we must see that her expertise in light of her previous position, and then look at her position as a medical research assistant.
No, they could be different. Could it not? Anyway, let me not stop you. Please carry on.
Much obliged, Your Honour. The prosecution urges that jurisdiction be assumed over this case. 3 points will be made in support. First, this court has jurisdiction pursuant to Article 13C, given that the prosecutor has commenced investigations for prior motive. Second, this court's jurisdiction is not affected by the prosecutor's continuance of investigations even after Arcania's effective withdrawal from the Rome Statute, because acts that constituted crimes against humanity were sufficiently linked to matters that initially triggered the jurisdiction of the court. Third, given that Ms. Minsa's involvement with the gas vans predated Arcania's withdrawal, jurisdiction can at the very least be assumed for the charge of genocide. On my first point, we submit that the court's jurisdiction under Article 13C was properly triggered when the prosecutor commenced his investigations pro prior motu. In order to do so, he had to comply with three requirements under Article 53(1) of the Rome Statute. First, he needed to have a reasonable basis to believe that crimes were occurring. Second, the case is admissible before the ICC. And third, there were no reasons in the interest of justice why he should not investigate the matter. Under the first requirement,
Sorry, which subsection is this?
this would be Article 53, subsection 1.
Okay. Okay, yes. Carry on.
Yes. Under Article 53, subsection 1A, the first requirement is that of a standard of a reasonable basis to believe. And this standard is a fact-sensitive one. As the pre-trial chamber in the Kenya case in the year 2010 explained, the prosecutor only needs to show the occurrence of a crime is one reasonable conclusion that can be drawn from the evidence. He need not satisfy himself that this is the only reasonable conclusion. The reason this test is at such a low threshold is because the purpose of this test is simply to weed out frivolous and politically motivated investigations.
When you say this case shouldn't be needed.
This case shouldn't be weeded out, no, no. Because at the time of the investigation, it was indeed reasonable. The prosecutor did have a reasonable basis to believe that genocide had been, pursuant to Article 6, had been occurring.
Yes.
At this stage,
perhaps it's appropriate for us to turn to the facts.
yes, Your Honor.
Yes.
So at this stage, we will look at the events that preceded November 2010, when the prosecutor commenced his investigation.
Yes.
So before that, the RAP had targeted victims belonging to a specific religious group, namely the Kapo community. And this is one of the requirements of genocide, which is targeting communities based on either ethnic or religious lines. In this case, the RAP targeted an entire religious community and blamed them for the economic situation of the country. When it called for
Does genocide include religious groups?
it does, Your Honor.
Okay.
So when they called out for spiritual destruction of Archania, the members understood it to literally mean the spiritual destruction, and then they went and destroyed spiritual sites of the Kapo community. After that, RAP then went and established the PSF, the Presidential Special Force, to terminate and suppress resistance.
Well, we don't know who established them, right? Do
The RAP established that.
we? And where do we find it? It is an inference that you draw from paragraph 5.
Yes.
Okay, carry on.
It's an inference we draw
Yes.
because in September 2010, the Revolutionary Arcanian Party won the election, and hence it's a reasonable conclusion to draw since they were in power and they had the capacity and the resources to establish the PSF, especially if they went on a statewide, if they had a statewide aim.
Including the fact that they use the word presidential, right?
Exactly, Your Honor. Yes, thank you for that. So following that, again, this must be seen in light of RAP's previous calls to destroy spiritual ambitions, but then it was interpreted literally and spiritual sites were destroyed.
So the intent might not be to destroy sites, might just be, let them know where they are, or where they ought to be in society, something along those lines, rather than go out and burn their religious sites and stuff like that. So what really is the intent?
Your Honor, this must also be seen in light of how the RAP rather cleverly
And you're saying it's
abused.
deliberate, of course.
It's deliberate, and they abused. Initially, the economic situation of Arcania was pretty bad, and the political leaders happened to be members of the Kapo community. They tapped onto that sentiment, that negative sentiment that was present in the country, and then they channeled it towards an entire religious community. So it wasn't just confined to a political critic of politicians who happened to be members of the religious community. Rather, they blamed the entire Kapo community for the economic situation that Arcania wasn't. So this was an act of inciting hatred against an entire community simply based on the religion that they subscribed to. After
Yeah,
this,
but hating the community doesn't mean that I want to kill all of them. Does it necessarily
pardon me, Your Honor, I couldn't hear you.
that if you hate someone or if you hate a group of people, does it mean that you necessarily have the intent to wipe them out?
Doesn't. But in this case, they called on for certain acts of violence.
Intentionally call on people to do that?
They called
Or
on.
was it understood to mean?
It was understood to mean.
And is that sufficient for genocidal intent? So, for example, if one day we say that we should have a clean and green environment, and then people start going out and kill people wearing anything but green, for example, is that genocidal intent?
Let's have a clean and green environment. Your Honor, firstly, that wouldn't fall under one of the classifications for genocide, but I
Yeah, but assuming people understand that statement to mean, quite cleverly masked and disguised as a call for the killing of everyone that's not dressed in green, for example. Or everyone who supports a party or everyone that believes green is not sacred, for example.
yes, Your Honor.
Would that suffice as genocidal intent?
Just that act of giving a speech perhaps wouldn't, but it must be construed within the range of activities that in fact took place following that.
Yes.
So one
So what do we have here?
One, we have a reaction to that speech, which Your Honor said that doesn't
But
necessarily.
is the reaction reflective of the intent?
The reaction, in a sense, in this case, it is the prosecution submits a reasonable conclusion that can be drawn at the pre-investigative stage, but the prosecutor does not have sufficient information because he hasn't even conducted it. So he's relying on the information that is sent to him by either NGOs or the UN. And we could also perhaps look at the events unfolding in December 2010. Admittedly, it was after.
Which is after the
Yes, but it probably would shed light on how serious and grave the situation was. The UN Security
assuming they are
Council.
relevant.
Yes, Your Honor. The UN Security Council.
Assuming that I cannot withdraw, right? If I can withdraw, does it make a difference what happens after that?
After you deposit your notice of withdrawal,
Yes.
for 1 year, your withdrawal only. Arcania's withdrawal would be effective only 1 year after it deposited the notice. So yes, Your Honor, the prosecution does submit that it is relevant
Okay.
because the withdrawal only takes effect 1 year after the notice is deposited.
And all the events are before the 1 year has lapsed.
No, Your Honor, the gas vents.
Yes,
The
that's
investigation.
after
That's after.
the 1 year.
That's before the 1 year.
Okay.
effect.
Okay.
The acts relating to the crimes against humanity that happened after the withdrawal took effect.
Okay.
Yes, but the prosecution would submit I would submit in my second argument that the prosecutor was still empowered to continue investigating.
Okay.
So, with your honest permission, may I proceed with the next limb under Article 53?
And if I say no,
I will.
you will go back to the first point.
If your honor is dissatisfied with my first
Okay,
point, then I will
then-
go back to it.
Let's just move on.
All right, Your Honor. Much obliged. At the time of the investigation, it was also reasonable to believe that the case would be admissible. A case is admissible if the state has not initiated criminal proceedings and the situation is of sufficient gravity for this court to prosecute. On the facts, there is no evidence that Arcania commenced domestic prosecutions against Ms. Mitza. So that is satisfied. On the facts, the situation is also of sufficient gravity. Perhaps it would be instructive to look at the other case, the Kenya case, where the pretrial chamber authorized prosecutors for prior motor investigations. In that case, post-election violence in Kenya left about 3,600 in jail and about 1,000 dead out of its population, of 40.91 million. Quantitatively, this forms about 0.01% of its population. In this case, the RAP has directed its acts of destruction against the Kapo community, and this community forms up to 29% of Arcania's population. Arguably, the situation was substantially more grave in this case. Turning to my second argument, we submit that the prosecutor had the power to continue investigation.
Wasn't that your second argument? Haven't you moved on to your second argument already?
Oh, this was the second limb out of the first argument.
Okay.
My apologies, I did
Yes.
not make my structure clear. So I will now turn to my second argument, and the prosecution submits that the prosecutor had the power to continue investigations even after Arcania's effective withdrawal. In particular, he had the power to investigate the human experiments forming the basis of crimes against humanity, as those were sufficiently linked to the matters that initially triggered the investigation. Article 1271 allows a state to terminate its obligations by serving a notice of withdrawal, which becomes effective after 1 year. However, Article 127, Section 2, governs a state's obligations that survive this withdrawal. This includes the state's duty to cooperate with ongoing investigations that started before the date of withdrawal. At the heart
Yeah,
of this...
so the question really is what is ongoing, right? Ongoing investigation.
Yes, Your Honor. And the prosecution submits that we should use analogies from the Ivory Coast case, where the temporal scope of the prosecutor's investigations was decided upon. And in that case, the court held that a prosecutor had the power to investigate something that they call continuing crimes, which is a manifestation of the sufficient link test. These are crimes.
What's the threshold again?
Continuing crimes.
Something.
These are crimes that share the same state actors and occur in the same context.
Context being
Being a similar act of violence,
so the same state actors
Same
acting
state actors.
against the same victims perpetrating different crimes. Is that the same context?
The prosecution submits that it is, Your Honor.
So, for example, even if it's over a span of 10 years, different types of activities going on, as long as the parties are the same, and it's one attacking the other, that's fine. It's the same context. So, even if you withdraw, it's sufficient. Yeah, no, it's not sufficient.
As long as it happens in the same situation of violence, there's another case, the Mbarushimana case, where the pretrial chamber was explained this test better, and they said that it had to happen in the same context situation. So in that case,
Yeah, so what's the situation?
a similar, based on this prosecutor's interpretation of that case,
Based on your interpretation.
based on my interpretation of this case, yes, Your Honor, it would mean similar state actors and similar victims in that sense. Victims who are targeted because of certain reasons. And in this case, the RAP targeted what they collectively call the inferior elements. And they grouped together the religious people and the religious members of the Kapo community and the disabled.
So,
And it was
would you agree with me if I suggest that the term continuing crimes is quite inaccurate? Because the crime has been committed, there are various crimes, it's not exactly continuing.
Your Honor, it must be seen in light of...
No. Do you agree with me that it's rather inaccurate? Whether it's right or wrong, that's a separate point. Do you agree with me that it's inaccurate?
Perhaps, Your Honor, perhaps the terminology...
Maybe they should change the terminology.
Maybe they should.
Right.
Yes, Your Honor.
How about the test? Do you think maybe the test should fit the terminology?
The test shouldn't change, Your Honor, because there are some reasons why the test was elucidated. One of them is because the court astutely understood the complex nature of such international crimes.
Who
And
understood?
the pretrial chamber,
Okay.
in this case, understood the complex nature of international crimes, and they mentioned how certain state actors, in the case of Mbarushimana, it was the FDLR, if Your Honor may indulge my use of acronyms.
I have no idea what the FDR means, but it's fine.
It's
Yes.
a French name, Your
Yes.
Honor. I would make a fool of myself if I tried
Yes.
to pronounce it. Yes, Your Honor. So, the defendant in that case belonged to FDLR. However, during the prosecutor's time of investigations, he was inactive, yet the prosecutor had evidence that he was linked to the crime. And the case before the court was whether the prosecutor had the authority to investigate these crimes when the member or when that group was inactive. And then the court held that yes, it is indeed possible, because actors like FDLR, you cannot expect them to remain active throughout. And in fact, if they were ousted from the prosecutor's jurisdiction simply by virtue of them being opportunistically not active during that period of time, it would make it really easy for such criminals of heinous crimes to escape liability simply by going inactive for a certain period of time. So, in this case, yes, again, as long as there's a sufficient link, since Your Honor is pleased with my use of the term continuing crimes, as long as...
What makes you think I'm pleased? But then, go on, please.
So, back to the point of this case, Your Honor. The same principle is applicable to Article 127 because it is consistent with the purpose of the statute. The purpose of, Your Honor, the purpose of this provision, and these are firstly, the provision strikes a balance between facilitating existing investigations and the state's right to exit the statute. Because the same acts can constitute different crimes, compelling the prosecutor to distinguish at the investigative stage is impractical. Secondly, an alternative interpretation would allow state parties to frustrate ongoing investigations. A state party may simply delay the commission of its crimes until the withdrawal is effective. And we acknowledge, Your Honor, as you pointed out rightly, that what if something stretches on for 10 years? This continuing obligation, if it's taken too far, an argument could be made that it renders the withdrawal ineffective. However, this is precisely why a control mechanism in the form of a sufficient link test exists to limit the scope of the prosecutor's investigations.
Then why do you have to have the 1 year?
The prosecution submits that it's perhaps to allow certain administrative actions to be completed. For instance, if there's a base in the country or if there's paperwork to be done for that kind of thing.
1 year? That's rather inefficient. Would you agree with me?
Perhaps so. The Singaporean standard, it might sound inefficient, Your Honor, but I would imagine that with a very multinational...
By this court standard, obviously not.
I wouldn't say that, Your Honor. I would just say that this court is extremely thorough and...
With
like
paperwork, yes.
Unfortunately, it has...
Where I come from, they call it bureaucracy. But anyway.
In this case, both the gas vans and the experiments are systematic methods by the same state actor, Revolutionary Arcanian Party, which handles the PSF, and the MPF, to eliminate those they call the inferior elements. Thus, genocide and crimes against humanity were not isolated and separate crimes. Rather, they were manifestations of continuing crime executed by the same state actor. Moving on to my third argument. Even if the prosecutor's powers to investigate extended until the date of effective withdrawal, at the very least, this court can assume jurisdiction over the charge of genocide.
So this is an alternative argument.
This is an alternative argument, yes, Your Honor. Because the acts occurred before the effective date of withdrawal. Article 127, subsection 2, as I explained, already allows investigations.
Which section?
Article 127
Oh, yes.
allows for existing investigations to continue. However, if an argument is made that the prosecutor's act of continuing the investigation into crimes against humanity was an abusive process that taints the entire investigation, the prosecution submits that
Must it taint the entire proceedings?
it must not, Your Honor. The
No.
prosecution-
My point is, can it just taint a portion of it? Must it taint the entire thing?
In this alternative argument, we submit that if it taints a portion, let's say the crimes against humanity, we are agreeable to accept that. However, it will not taint the charge of genocide.
Okay.
So, yes, Your Honor. Again, in order for an abusive process to taint an entire investigation, it has to result in an egregious breach of the suspect's rights, which in this case the prosecution submits has not happened, because the court in the appeals chamber in Lubanga in 2014 held that for a stay of proceeding to be granted, the court needs to strike a balance between ensuring that suspects of the most heinous crimes are put on trial while the integrity of the judicial process is maintained. Further, the chamber held that the accused's rights must make his or her defense within a framework impossible, and only then will the judicial process be frustrated enough for the court to grant a stay of proceedings. It is perhaps instructive to look at the cases that Lubanga mentioned to see what sort of a violation constitutes an egregious breach of the suspect's rights. In the case of Lubanga, the defendant...
I'm not so concerned about that case. I'm more concerned about this case. Right? So, why is why do you think the defense is saying that it's affected by withdrawal? Why do you think they say it's an abuse of process?
Perhaps because the prosecutor continued the investigation.
Yes, and so how does that affect the defense of the defendants?
Perhaps they could make an argument that because the prosecutor exceeded his powers, this entire case should not be brought to the court.
Yes, so how does it affect his right to fair trial?
It does not, Your Honor. That's our submission.
No, I'm asking you their case. I know your case is that it doesn't, but what's their case?
I must submit, Your Honor, that as I was doing research for this abusive process, it took me a great deal of imagination to think of how what the prosecutor did could possibly constitute an abusive process. And the reason I mention this is because, to the best of my awareness, the defense had pleaded this, and hence I am...
But you think it's frivolous?
I think that, yes, Your Honor, it's not substantial enough. There's not enough evidence on the facts to show.
And you cannot imagine how it is possibly...
It can affect the fair trial process.
Right.
Because the defense in this case is
Because
still...
if you've committed it, it's committed it. You
No, you're
are
not.
still entitled to your procedural rights.
Yes, and they still have access to all the evidence.
Yeah, you just committed and sent to prison, but that's fine because you are...
No, Your
You
Honor.
have committed an offense, we hear your defense and send you to prison, that's fine.
We don't send you to prison, Your Honor. That would be...
And then, no?
No, Your Honor. That hasn't been decided by the court yet.
No, I'm...
So
of
they are
course-
they have the full capacity
Yes,
to in fact put a strong case and prove the prosecution wrong. If
Yes.
they
So
saw
it doesn't
understand.
matter that, I go out there, I have no authority, it's fine, as long as I get you, if committed a crime, you come, you have the right to defend yourself, that's fine, right? You have the right to fair trial, I mean, it's fine, right?
As long as... but in this
As
case...
long as we get our hands on you.
No, because in this case,
No?
there is a legitimate basis for charging them, for charging
Of
Ms.
course,
Minsa
there
over
is-
genocide.
Yes.
So because the court thinks that another crime that was investigated improperly by the prosecution cannot allow the court to look away from the charge of genocide. Because then what it would imply is that someone who's potentially responsible for a very heinous crime can go scot-free. In this case, the prosecutor we are not submitting that the prosecutor went on a frivolous run and then he managed to bring her in and then he said, oh, our court is fair and you are entitled to a fair trial, so let this not affect my investigation. Rather, the prosecutor did find something that she could be potentially liable for, and this is a very serious crime. However, just because he happened to continue his investigation into another crime that she could be responsible for,
Even if
Should
it's
not
wrong, it
remove.
doesn't matter.
should not remove her from the purview of this court to decide on whether or not she's liable for the first crime. It's because that was legally that
And they are just
investigation.
separate crimes.
This,
Separate but continuing crimes.
the separation is because of the withdrawal. There's still different charges under the Rome Statute. One is governed by Article 6, the other is governed by Article 6.
Separate what? Continuity.
Substantially, because the evidence is different.
Substantially separate,
And-
but continuity.
Yes, Your Honor.
Okay. Yes, I got you.
In light of
Go
this,
on.
the prosecution strongly urges the court to assume jurisdiction in this case, and unless Your Honor has further questions, this concludes my submission.
Thank you.